Did you know the Enforcement Directorate can freeze your bank account or attach your property without going to court first? Many people find out only after it has already happened. By then, they have just 180 days to respond before the attachment is confirmed. In this video, I am going to break down exactly how ED attaches properties and bank accounts under the Prevention of Money Laundering Act 2002, step by step, and most importantly, how you can challenge it. Under Section 5 of the Prevention of Money Laundering Act, the ED has the power to issue what is called a Provisional Attachment Order, or PAO. A PAO is an administrative order. The ED does not need a court's permission to issue it. The Director of Enforcement or any officer authorized by him of the rank of Deputy Director and above can pass this order. The law requires that the officer must have reason to believe, based on material in his possession, that the property in question represents proceeds of crime, and that if it is not attached immediately, it may be transferred, concealed, or dealt with in a manner that will frustrate any future proceedings. This belief must be recorded in writing before the PAO is issued. The ED can attach an extremely wide range of assets. This includes immovable property, land, residential flats, commercial premises, movable property, jewelry, vehicles, shares, mutual funds, bank accounts, current accounts, savings accounts, fixed deposits, and even lockers. Foreign assets, properties or accounts held abroad if they are linked to proceeds of crime. The key legal concept is proceeds of crime, defined under Section 21U of PMLA as any property derived or obtained directly or indirectly as a result of criminal activity relating to a scheduled offense. This scheduled offense could be under the Income Tax Act, IPC, Companies Act, or dozens of other statutes listed in the schedule to PMLA. Let me walk you through exactly how this works. Step 1. The ED receives information from a police charge sheet, an FIR, or its own intelligence. Step 2. The authorized officer forms a reason to believe and records it in writing. This is a critical safeguard. A vague or absent reason can be the basis to challenge the attachment. Step 3. The PAO is issued. Copies are served on the person whose property is attached and also on the property registrar or the bank. Banks are directed to freeze accounts immediately. Step 4. Within 30 days of the PAO, the ED must file the case before the Adjudicating Authority seeking confirmation of the attachment. Step 5. The Adjudicating Authority issues notice to the affected person and gives them an opportunity to be heard. Step 6. Within 180 days of the PAO, the Adjudicating Authority must pass an order confirming or releasing the attachment. If no order is passed, the attachment automatically lapses. The Adjudicating Authority is not a court, but it functions like one. It can examine witnesses, call for documents, and hear arguments. The standard of proof at this stage is balance of probabilities, which is lower than the criminal standard of beyond reasonable doubt. This makes it easier for the ED to secure confirmation. However, the affected person has important rights. First, the right to file a reply challenging the attachment. Second, the right to appear through a lawyer. Third, the right to produce documents showing the property was acquired from legitimate disclosed income. If confirmed, it remains attached pending trial. If released, it ends immediately. Now, the most important part. What are your legal options if your property or bank account has been attached? Option 1. Before the Adjudicating Authority, file a detailed reply under Section 8. Attack the legal basis, show that the property has no nexus with the alleged crime. Option 2. Appeal to the Appellate Tribunal. Under Section 26, you can appeal to the Appellate Tribunal for forfeiture of property within 45 days. Option 3. High Court under Article 226. If there is a jurisdictional error or violation of natural justice, you can directly approach the High Court by way of a writ petition. Option 4. Claim by third parties. If you are a third party, a bank with a prior mortgage, you can file a claim establishing your prior right over the property. To summarize, The ED can attach property administratively under Section 5. It must be confirmed within 180 days, and you have meaningful rights to challenge it. If your property has been attached, act immediately. At Wazirs, we advise clients on ED matters. Visit wazirs.in or reach us on WhatsApp. Like, share, and subscribe.